Hello students, my name is Dr. Alice Mani. I will be imparting lessons on Business Law, course 306. I am the resource person for Mahatma Gandhi National Council of Rural Education. I will be imparting lessons on business law. This is part of the BBA Rural Management course. This unit, that is Chapter 3, is titled Sale of Goods Act 1930, and this will be covered as 4 video lessons. The first video lesson will look at the basic features of the Sale of Goods Act 1930 and types of goods. The second video lesson will cover conditions and warranties. The third video lesson will cover the rights of an unpaid seller. The fourth video lesson will cover buyer's rights against the seller and the duties of the buyer. We will cover the third video lesson of the third chapter or third unit, which is rights of an unpaid seller, in this video lesson. So let us go ahead and understand the topic in details. I have structured this lesson in the following way. This lesson will cover 4 broad topics. The topics we cover in this video lesson are meaning and characteristics of an unpaid seller, rights of an unpaid seller, distinction between right of lien and right of stoppage in transit, and the last topic is rights of an unpaid seller against the buyer personally. The first objective is to provide the meaning and characteristics of an unpaid seller. Second objective is to give information about the rights of an unpaid seller. The third objective is to give the distinction between right of lien and right of stoppage in transit. The fourth objective is to provide information about the rights of an unpaid seller against the buyer personally. At the end of this lesson, you will be able to understand the basic features, characteristics, and rights of an unpaid seller. Thus, you will get information about the legal consequences, rights and privileges of an unpaid seller, and buyer's rights against the seller. This will be helpful for those who will become entrepreneurs in future or to understand the basic legal implications as consumers. Moreover, this will equip us with the basic knowledge to be more alert and responsible in protecting our legal rights as consumers, as a seller, manufacturer, distributor, wholesaler, retailer, buyer, or a service provider. Moreover, the knowledge about the rights of an unpaid seller will guide us in entering the right transactions and not to get cheated either in the online or offline mode of purchase. So, let us understand this topic in details. Now, let us understand who is an unpaid seller. Have you heard of this term before? I don't think so. So, I will share the information which will be your guiding principle for future transactions. Unpaid seller is the person who sold the goods but has not received the full payment for the same. If the unpaid seller receives half payment and half is remaining, he is also an unpaid seller. Under the Sale of Goods Act 1930, an unpaid seller is a seller who has not been paid the full price of the goods sold, or he has received a bill of exchange or any other negotiable instrument as conditional payment, but the condition for the same has not been fulfilled. That means the negotiable instrument was not honored when presented for payment. An unpaid seller is defined under Section 45, subsection 1 of the Sale of Goods Act 1930. Three features describe an unpaid seller from this definition. So this 3 points are, or the three characteristics are: seller has not received the entire price. Second point is the negotiable instrument is accepted as a conditional payment. And third point is that the negotiable instrument is not honored while presented for payment. Now let us learn the characteristics of an unpaid seller. There are 4 points we can give as characteristics of an unpaid seller. They are: goods are sold on credit, but buyer has not made the payment either fully or partly. The negotiable instrument the buyer has submitted as guarantee for future payment is dishonored while presented for payment. The seller has not refused to accept the payment when tendered by the buyer. Now let us see the rights of an unpaid seller. Rights of an unpaid seller is broadly divided into two. That are rights of an unpaid seller against goods, and second is the rights of an unpaid seller against the buyer personally. The rights against the goods of unpaid seller are divided into two subheadings. That are, firstly, where the property in goods is passed, and second is when the property in goods is not passed. That meaning property in goods is passed to the buyer or not passed to the buyer. If the property in goods is passed to the buyer, then it has 3 more subdivisions, that are lien, stoppage in transit, and resale. Similarly, if the property in goods is not passed to the buyer, then it has 2 more subdivisions, that are withholding delivery and stoppage in transit. Similarly, rights of an unpaid seller against the buyer personally are subdivided into 4, that are suit for price, suit for damages, repudiation of the contract before the due date, and lastly suit for interest. Now let us learn these topics in detail to understand the rights of an unpaid seller. Now, what is lien? Have you heard about this term lien? Lien is the right to retain the possession of the property of another till the other person meets the demands of the person in possession. The demand could be anything like performing a duty or paying the balance amount due. During the developments of trade and commerce, the common law considered lien as a self-help practice. It was named as self-help as it did not require any intervention of the courts. When there was further progress in trade and commerce, the court recognized that having such primitive remedy or such primitive remedies freely can lead to every person recklessly holding or on whatever he had. That meaning whatever they received as lien, they may be withholding that. They will not be returning to the other party. Therefore, ultimately it can hamper trade and commerce. Lien was in the nature of the remedy and it was recognized as a right. The basis of the contract of lien was that it was not between the parties and the party had its rights because it was imposed as law by the common law courts. The Honorable Supreme Court explained the nature of the right of lien by stating that lien in its elementary sense is a right of a person to retain the possession of goods until the demands of the possessor are satisfied. Therefore, the right of lien is a right granted by law and is merely not granted by a court. For example, if we take a bank loan by pledging share certificates, till the bank loan is fully paid, the bank will get the right of share certificates as it is endorsed in bank's favor. When the loan is fully paid up, the applicant will get back the share certificates, ownership in his name. So 2 points are very important with regard to lien from our point of discussion so far. First point is, lien is the right of unpaid seller's right to retain goods. Second condition is the unpaid seller can refuse to deliver the goods till the payment is made. Now, let us learn the rights of an unpaid seller against the goods. This right can be exercised only if the property in the goods is not passed to the buyer. The options available with the seller can be classified into three, that are right of lien, right of stoppage in transit, and right of resale. Have you heard about these terms? Right of stoppage in transit, resale, lien. I don't think so. Lien we have already covered, and resale you might have heard about that. Whereas not the stoppage in transit, I assume. So let us learn these topics in detail. Right of lien is explained in sections 47 to 49 of the Sale of Goods Act 1930. Let us understand the meaning of lien. Lien, as I told you, is the right to retain possession of goods and refuse to deliver them to the buyer until the price due in respect of them is paid. The unpaid seller's lien is a possessory lien. That is, this lien can be exercised as long as the seller has possession of the goods. Another important point worth mentioning in this regard is that this right can be exercised only for the non-payment of the price. This right cannot be exercised for meeting other expenses of the seller like maintenance, insurance, go down rent or custody charges. The seller may have to incur these expenses if he has to keep the goods again to collect the money from the buyer. These charges the seller may have to incur for keeping the goods in order to collect the price of the goods from the buyer. Now, the next thing we have to learn is about when the seller can exercise these rights against goods. There are three situations to exercise this right by the seller against the buyer. That are, first, where goods have been sold without any stipulation as to credit. Second, where the goods have been sold on credit but the term of credit has expired. And third and last is where the buyer becomes insolvent. Now, let us sum up the important points regarding right of lien available to the seller. First point is that this right of lien, as already mentioned and understood, is a possessory lien. The seller cannot exercise this lien once he parts with the goods. That meaning the goods have come to the custody of the buyer or his agent. Secondly, lien is with the actual possession of the goods and not with the title of goods. Thirdly, the right is only for recovering the price of goods and not for meeting the additional expenses of keeping the stock in seller's possession till the payment is collected. Fourth point is, if the unpaid seller has made part delivery of the goods, he can retain the remaining goods till the payment is made by the buyer. The unpaid seller loses his right of lien on the goods in the following circumstances. First, if he delivers the goods to a carrier or other bailee for the purpose of transmission to the buyer without reserving the right of disposal of the goods. Second, if the buyer or his agent lawfully obtains possession of the goods. Third, if he waives the right of lien on the goods. The seller may waive his right either expressly or impliedly. Have you heard of these terms? Express and implied. If the contract of sale itself provides in express terms that the seller shall not retain possession of the goods, even if the price has not been paid, it is said to be an express waiver of lien. Implied waiver of lien takes place when the seller sells the goods on credit or grants a fresh term of credit on the expiry of the original term of credit. Now, what is the next step possible as a legal remedy to the unpaid seller? That is the right of stoppage in transit. What is this right? Do you have any idea? It is a right of stopping the goods while in transit after the unpaid seller has lost possession of the goods. This right enables the seller to regain possession. Goods are deemed to be in the course of transit if they are delivered to a carrier or other bailee for the purpose of transmission to the buyer until the buyer or his agent takes delivery of them. But please remember that the unpaid seller has this right only under two circumstances. First is the buyer being insolvent, and second is when the goods are in transit. Let us see the differences between right of lien and right of stoppage in transit. As the first distinction, we can say that the unpaid seller can exercise the right of lien only if he keeps possession of the goods, whereas the unpaid seller can exercise the right of stoppage in transit if he has lost possession of the goods. Second distinction is the right of lien can be exercised when the buyer is able to pay but does not pay, whereas the right of stoppage in transit is available only when the buyer is insolvent. Third distinction is the right lien comes to an end the moment possession of the goods is lost by the unpaid seller, whereas the right of stoppage in transit commences only when the seller has lost possession of the goods. The fourth and last distinction is the right of lien is a right to retain possession, whereas the right of stoppage in transit is a right to regain possession. I hope it's clear what is the distinction between lien and stoppage in transit. Now let us see how the right of stoppage in transit can be exercised by the unpaid seller. 2 points are important in this regard. First is by taking actual possession of goods. Second is by giving notice to the bailee who has actual possession of the goods. Now, who is a bailee? Bailee can be the person who has actual possession of the goods. For example, like a godown manager, or it can be the principal of the buyer also. The next option possible to the unpaid seller is the right of resale. Please remember that this right is available only in the following cases. First, if the goods are of perishable nature. Second, the unpaid seller has to give a notice to the buyer. The third point is related to the second point. That is, if the unpaid seller has the right of resale as per the contract, then there is no need to give notice to the buyer. If on resale, the seller incurs loss, he can claim the same from the buyer as damages for breach of contract. But if there is a profit on resale, the seller is not bound to hand it over to the buyer. If the property of the goods has not passed to the buyer, the unpaid seller has, in addition to other remedies, he has another right, that is right to withhold delivery. These rights of the unpaid seller against the buyer are called rights in personam. These are as follows. First, if the property in the goods has passed to the buyer and the buyer wrongfully refuses to pay for the goods, the seller can sue him for the price. Second, even if the property in the goods has not been passed to the buyer, the unpaid seller may sue the buyer for the price, provided he wrongfully refuses to pay. Third, the buyer wrongfully refuses to accept and pay for the goods. the seller may sue him for non-acceptance. Fourth, if the buyer abandons the contract before the date of delivery, the seller may treat the contract as existing and wait till the date of delivery, or he may treat the contract as cancelled and sue the buyer for damages for breach of the contract. Fifth, if there is a specific agreement between the seller and the buyer as to interest on the price of the goods from the date on which payment becomes due, the seller may recover interest from the buyer. If there is no such agreement, the seller may charge interest on the price when it becomes due from such day as he may notify to the buyer. Our learning wouldn't be complete if we don't assess what we have learned. So here I am giving one activity for you. Right in personam is available against a particular individual only and is generally positive. We have already explained that concept. Identify the right that is available against the whole world and write a brief note about it. I hope you can do that. Now that we have reached the end of this lesson, I hope that you have learned the meaning of unpaid seller, characteristics of an unpaid seller, rights of an unpaid seller, the distinction between right of lien and right of stoppage in transit. I hope you got a good insight on the topics we discussed in this video lesson. To conclude, in this chapter of Sale of Goods Act, the first video lesson we covered was about the basic features of Sale of Goods Act and the types of goods. In the second video lesson, we covered about the conditions and warranties. The third video lesson we covered now is about the rights of an unpaid seller. The next video lesson is the last and fourth module from this chapter, that is the rights of buyer against the seller and duties of the buyer. Until we meet again, bye, thank you.